So think about this for a second. What makes the US Constitution's intellectual property clause completely, utterly unique compared to literally all the other powers granted to Congress? I mean, Congress can tax, they can borrow money, they can regulate commerce, right? But only one clause in Article 1, Section 8 comes with its very own built-in philosophical justification. To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. See what they did there? The framers didn't just throw in some boring administrative rule for trade. No, they tied a massive public welfare goal, the actual advancement of human knowledge, directly to a temporary private property right. Welcome to The Explainer. Today, we're diving into the constitutional crucible and the useful citizen. We're going to take a really fascinating look at the socio-political heart of the American patent system. As you'll see, this totally unique framework wasn't just engineered to build better machines, it was actually designed to build better citizens. Here's our roadmap for today. First, we'll look at the constitutional IP blueprint. Second, rejecting elite European monopolies. Third, the rise of the useful citizen. Fourth, democratizing American invention. And finally, number 5, the system's lasting legacy. All right, let's jump right into Section 1, the Constitutional IP Blueprint. Okay, picture it. It's the summer of 1787. The Constitutional Convention is in full swing, and the foundation for American innovation is literally being debated in real time. This IP clause didn't just magically appear out of thin air. You had James Madison from Virginia wanting to secure exclusive rights for authors and inventors. But then you had Charles Pinckney from South Carolina pushing for a system of federal premiums and payouts to encourage discoveries. The convention ended up pulling off this brilliant compromise. They synthesized these competing ideas into a single mechanism, a temporary private property right that was explicitly designed to serve the public good. Now, we do need to quickly clarify what words meant back then, because 18th century English can be a bit tricky. When the Constitution says science, it broadly meant human knowledge and learning, which copyrights for authors would cover. And when it says useful arts, they specifically meant technology, engineering, and manufacturing crafts. And that is exactly what the founders wanted to boost by giving inventors those exclusive rights. Moving right along to Section 2, rejecting elite European monopolies. To really get why the framers built this system, we kinda have to look across the Atlantic. Like, what was the aristocratic problem they were so desperately trying to avoid? Well, the British system relied on letters patent, which were basically privileges handed out on a whim by the crown. We're talking arbitrary state-sanctioned monopolies that often had zero to do with actual innovation. Get this, Queen Elizabeth I gave Sir Walter Raleigh a super lucrative patent just to oversee England's taverns. Crazy, right? The American model completely rejected that nonsense. They demanded actual, strict novelty and totally scrapped the idea of rewarding well-connected elites who weren't actually inventing anything. And this wasn't just some philosophical difference, it was a massive financial one. Let me put this in perspective. In the mid-19th century, dealing with the British system, with all its crazy fees and required bribes, would cost you the equivalent of about 37,000 modern US dollars. In the United States, just $618. That is a total game changer. The European system was literally built for wealthy oligarchs, while the US system was mathematically engineered for the everyday citizen. Which perfectly tees up Section 3, Rise of the Useful Citizen. Now, what's really interesting here is that this super accessible, cheap system wasn't just an economic play. It had a deeply hidden socio-political objective. Enter this incredible concept of the useful citizen. Back in the early republic, a patent wasn't just a way to make money. It was a powerful credential from the government. Holding a patent legally proved that you had originality, independent thought, and the exact kind of intellectual capability needed for democratic self-governance. It essentially certified that you weren't just a follower, you were a creator. Because of this, patents became group credentials for an inventive, self-governing people. The historical records on this are wild. Even when startup republics like the Republic of Texas or the Confederacy were totally cash-strapped and fighting for their lives, they still prioritized setting up patent offices. Why? Because they genuinely believed, just like the early US did, that a functioning republic absolutely required an inventive citizenry. It was literally nation building through innovation. But hold on, we do have to be real about the historical duality of this system. The original ideal was beautifully inclusive. It was all about waking up the dormant genius across the whole nation. But the historical reality, that legal personhood, that status of the useful citizen, was initially largely restricted to white men. Now, the system absolutely did evolve later to include brilliant female and black inventors, sometimes even before they had the legal right to vote, but we have to acknowledge that the early useful citizen credential was frequently tied to restricting full civic rights.
Okay, Section 4, Democratizing American Invention.
So, balancing that grand ideal with the messy history, how does a patent system actually build an inventive society on a practical mechanical level? Honestly, it boiled down to some incredibly radical bureaucracy. The US allowed people to apply by mail. They waived postage for the physical patent models you had to submit. The fees, like we talked about, were rock bottom. And absolutely crucial here, they completely rejected those European working requirements, which basically forced inventors to manufacture their goods or forfeit their patent. In America, you didn't need to own a factory. You just needed a really good novel idea.
And the results? Immediate and explosive. Data from the National Bureau of Economic Research completely backs this up, showing how these low costs and structural flexibilities basically democratized invention. Since you didn't have to instantly manufacture a product, a superfluid secondary market popped up. Lone inventors, farmers, people without any capital, they could focus purely on research. They'd secure their patent as intangible property and just license it out to investors. It was brilliant. Naturally, the system had to grow up fast to handle this explosion of creativity. In 1790, the first Patents Act required a really strict examination. Then in 1793, they briefly tried a simpler clerical registration before finally setting up the modern patent office in 1836 with full-time examiners. Even Thomas Jefferson, a guy who famously hated monopolies, personally helped administer that 1790 Act and was just blown away. He actually wrote that it gave a spring to invention beyond my conception. Which brings us to our final section, Section 5, the system's lasting legacy. We know the system was carefully calibrated from day one to promote the general welfare. But how did it cement its legacy globally? Simply put, radical transparency. The government made it so literally anyone could walk in and view patents for free in Washington. You could order super cheap copies through the mail. They printed and shipped annual reports all over the country. They even built a massive physical patent office museum just to show off the invention models. They were basically open sourcing inspiration so the public could immediately invent around or improve on existing ideas. And this framework fundamentally changed the American economy. Abraham Lincoln, who actually held a patent himself, by the way, famously summarized it best. He said the patent system added the fuel of interest to the fire of genius. That is such a perfect way to put it. The system beautifully aligned private financial incentives with the public's desperate need for technological progress. But let's leave off with a bit of a provocative question. Today, a single modern smartphone can be covered by up to 250,000 active overlapping patents. Experts literally call it a patent thicket. So you really have to wonder, does the modern U.S. patent system still serve its original constitutional purpose of credentialing the everyday useful citizen? Or have these incredibly dense webs of corporate protections accidentally recreated those exact same elite, impassable monopolies our founders were running away from? It's a tough question for sure, but one we definitely need to keep asking to keep that fire of genius burning. Thanks so much for joining me on this explainer, and keep questioning the systems around you.